Hello, everyone. Welcome to another episode of the Unisolve Question. My name is Pulat Yunusov. I'm a commercial litigator here in Toronto, and my wonderful guest today is a personal injury lawyer here in Toronto and in the Toronto area. His name is Peter Cho. He is with Smitiuch Injury Law. Hello, Peter. It's great to have you.
Oh, thank you so much, Pulat. It's great to be on your show today, and thank you for having me. I really appreciate it.
Well, we hope to learn a lot from you today. So I think I owe you more than you owe me because you bring a wealth of information about personal injury. You bring a wealth of information about trials. You bring a wealth of information about things that we all want to know more about. So I can't wait to start asking my questions. But let me start with a controversial question. Is personal injury a business or a professional?
Oh, great question. Great question. It all depends on the lawyer. For me, it is not my interest. I'm not a business guy. It's both. So I know that's not an easy answer. It really depends on the lawyer. I treat it not like a business. I understand the business side of it, but it's actually the best area because of the fact that it is personal. You connect with these clients from start to the finish, and you know them inside and out, their families, their whole story. So that's the way I approach it. So my answer would be, yeah, no, I don't think it's a business, but for me, but certainly it is in some ways treated that way by other lawyers, or could be, I should say.
Give me a bird's eye view breakdown or assessment of the personal injury bar in Ontario. By
Oh,
choose any category you want to break it down, but break it down for me. Do some analysis, please.
oh, great. Yeah, good. Very good question. Because as a lawyer, your perspective on it is, yeah, what is the bar like? So, personal injury lawyers, I would say, fall into different areas. There's lawyers who do a lot of trials, like our firm. Um, I had the ability to do trials very early on in my career, and I love doing them. So there's personal injury lawyers who look at a case and take it to trial or think that way. And if it settles, it settles. Majority cases still settle. So that's one area of the bar. The other bar, a portion of the bar, are lawyers who um, are very good at getting cases, analyzing the case, getting a case to conclusion at a certain point, and they may pass off the file to a lawyer who does trials. That's not uncommon in personal injury law. Lawyers may take it to a certain stage of the litigation and no further. And then you have, um, I've been asked quite a few times, back when you used to do discoveries in person, pull out and you'd run into people at Network Downtown or Network West, and other personal injury lawyers who are doing discoveries would ask, hey, I've got these cases where they're going to go to trial. We've taken it this far. Would you be interested in taking it over, running some trials? So that does happen. And so there's two different, I guess that's pretty much the categories I would say in the personal injury bar. Um, and so at our firm and for myself, I look at a case and I think, well, I'm going to go all the way. So I want to plan it very early and learn as much as I can.
How did you know that you love doing trials? Was this an accident? You ended up at a trial firm, or you knew from the beginning?
Um, I have been with Smitiuch Injury Law since I started as even a summer student, articling student, and then a lawyer. I think I did a trial very early, a big trial against a corporate defendant in a personal injury case. And then after doing that trial and preparing for that trial, I really just I figured it's the best way to do it. So I came into this area, um, and I could tell you the story of how I came into personal injury law afterwards. But becoming a trial lawyer and doing trials became just doing it. Doing the first one became why I fell in love with it. And I encourage a lot of the articling students and lawyers who who want to do litigation, who say they want to do litigation, just do a trial, and you'll really know if you want to do litigation because That's thinking on your feet every day for weeks, being a solid advocate every day during the trial, and it's a great experience. And at least for me, everyone's different, and people have strengths, and people enjoy things about the law differently. For me, it's the trial work. So I think doing my first trial was within 2 years of being called, and it was a 6 week trial in London, Ontario. Um, and I remember so much about that case because it had everything in it. It was trial by fire, but not entirely. Mike and I did it together. Um, but in terms of just going into there and seeing it all happen, doing my first trial, I was second chair, of course, but I got to do witnesses, experts even. So you go through something like that, it really shapes how you see your career. And ever since then, I've been doing trials pretty regularly, um, probably one every single year since then. So, like to the end, to verdict. I've started trials where we've settled, of course, but I'm talking trials that have gone to verdict.
How many?
I think at least 10, I would say that's gone to verdict.
Mhm.
Um, and I must say, as a lawyer and I like sports and I'm a competitive guy, but the rush of waiting for a jury verdict,
Yeah.
when the court staff calls you and says on your cell phone when you're waiting and says the jury's ready for you, they have their verdict. It's not a question, it's the actual verdict. And you're in the courtroom just pacing, waiting for it. It's quite a feeling.
Yeah.
Um, the culmination of everything, right? All the years of prep, all the trial itself too, and the family's there. Typically, my clients are
Yeah.
there waiting to hear, and um, luckily we've been successful on them, so it's been a good feeling.
Have you ever had a feeling of loss when you wait for the jury verdict and they tell you that the claim is dismissed?
I've had that once, and yeah, I think you learn from the losses too. I think you have to do trials and win and lose. And it's not really the outcome. Obviously, it felt when it hasn't gone my way, of course. Um, but it goes both ways, I think. But majority, I've only had one experience like that, and it wasn't good, but they've had offers and you kind of reanalyze everything. It does
Yeah.
sit with you, but you learn, I say, as a younger lawyer too, at the time when I was doing trials, or those trials, I should say, you learn from the losses or the cases that even when you win, I studied the defense lawyer quite a bit just to see what tactics, strategies they're employing, and then you learn from that. You anticipate it for the next one. So, it's a very good experience for learning how to be on your feet and be a good litigator, I would say.
I think what a lot of people who don't do trials are missing is the FaceTime with the judge, the incredibly long FaceTime with the judge and getting to know the judge. What do you have to say about that?
Yeah, that is very true, Pula. I think there's a lot of great judges out there. I can't say I've had a bad one as a trial judge, and they all have different views. Um, Judges are funny, some of them. They have a sense of humor.
Yeah.
They understand the case. I've been before so many judges in various regions, and I really respect all of them because they have a passion really for justice. So let me give you an example. We had a trial in Hamilton before Justice Skarica. I've appeared before him on another matter. Anyways, when he's doing jury selection, Justice Skarica comes into the courtroom and tells the body of the court where everyone's waiting for jury selection, it's important that you take this duty seriously because this is what we want in society. We want the community to decide issues. So, if you're up here and you get selected, I want jurors who want to be here. And, we've heard this, you get calls, hey, my friend got a notice for jury duty. How do they get out of it? Or something like that, right? It's the first
Yeah.
question. But I was very impressed by how judges really want the jurors that want to be there. I had a jury trial during COVID that I started, and we picked the jury. This was in Brantford, and I was so impressed by the lack of excuses. And this is during COVID. Everyone was wearing masks. We had the plastic screens up everywhere in the courtroom. And we picked a jury in 30 minutes. I think two may have asked to be excused. And the judge, I think it was Justice Grace, anyways, had said, if you do have nervousness because of COVID or whatever, let us know. And I think he was going to allow some jurors to use that as a valid reason. None of them did in Brantford. So I was very impressed by that. We started the case, we did opening statements, and then picked the jury, did opening statements, and then we ended up resolving that one actually right after the openings. But it was a very good experience, and I do really enjoy Brantford. The courtroom's really nice. I don't know if you've been there, Pulak, but it's a very old fashioned. It's got paintings on the walls, like it's got the actual bar in front, and it feels like you're walking into what we envisioned when we were kids, like a courtroom. So
Yeah. I want to talk a little bit about your origin story, and I Googled your name so I could research a little bit about you. And you know how many Peter Cho's came up, and they're doing all kinds of things. There is an engineer, a designer, a chef, a
you see a
pastor.
prisoner?
So
That's a running
they're
question.
all doing great things, and I was looking for you, and you're at the top of the list. You're a lawyer,
Oh wow.
and yeah, you're at the top of the list, at least in Canada, at least for me. And I wanted to ask you about your path to law. I know now you told me about your path to your trial firm, to your trial practice, but tell me more about your parents. Tell me how your parents raised you.
Sure.
Tell me if it was their idea or if it was your idea. Tell me what happened there. I'm really curious to hear.
Oh, well, I'd be happy to share that. My parents are both Korean. I'm a second generation. I was born here. I have an older brother who's 4 years older, who's into art therapy, and he's a therapist. My upbringing was, we were financially kind of struggling at times, but doing my parents hard at working, raised us to be sort of work ethic was a big thing. School was obviously a big thing. Um, did well in school, and was lucky to eventually become a lawyer, get into law school. But even before that, my parents worked together. Um, I was raised in north part of Tobico called Rexdale. I went to school. I'm obviously visible minority. There weren't a lot of Korean and uh, other Asian cultures when I was growing up. So it was my parents still live in Rexdale, so I still go there. Really got involved in the community ever since I was younger. Yeah, so in terms of being a lawyer, my parents, yeah, they pushed being a lawyer, doctor too, my mom engineer kind of thing. Those typical kind of professions that when you come to the country, you immediately respect and admire. At least my parents did. So they kind of steered that, but being a lawyer, I think they were happy with that choice, typical Asian kind of parents, but they didn't necessarily push the one profession, I would say. What really, and I've told my clients this, is unique, and if you've seen some of our social media at our firm, is when I was 16 years old, I was in a car accident, very serious one with my father, and personal injury claim arose from that. He was catastrophically injured. I still think about it to this day, and it really fueled kind of where I would take my career. I wasn't a lawyer, obviously, at the time. I wasn't even sure I wanted to be one, but through that experience, really, I became. It was an eye-opening experience. Recovering from injuries, seeing what my father's going through, see what the family, my mom, my brother are going through. Um, you need a lawyer to navigate that process, really. There's so many little rules, so many things in the insurance world that restrict what you can and cannot receive. You do something wrong, sometimes they can take advantage of those mistakes and errors. It's really hard, especially for my parents who can speak English pretty well now, but couldn't at the time. Um, you need help. So when I meet a new client who's in an accident, I can definitely relate to how overwhelming everything can be, how long things can be. Civil personal injury cases take time. There's a lot of delays. They're kind of bumped in terms of trial priority too. Sometimes I hear when we're right about to go to trial, we don't have a judge, we don't have a courtroom. But that's been actually better in recent times. But it does take quite a time. So that's part of my story in terms of why I became a personal injury lawyer specifically. Um, well, we went to the same school, so there's intensive programs, and um, even before that, though, I volunteered at the Rexdale Community Legal Clinic. It's in the Woodbine Shopping Mall. I met some really passionate lawyers there who kind of also, this is before I did PI law, that kind of pushed me into helping people who don't have an advocate, who can't afford an advocate. And so that kind of, when I went to law school, motivated me to work in the legal clinic in Parkdale, where I worked there. And I enjoyed every minute of that experience. And um, then personal injury was a natural kind of flow. People are hurt, people are disabled, and looking for someone to sort of speak up for them and act as their advocate in court.
You do amazing work for injured people. You do amazing work for families who went through tragedy and through trauma. And I have no doubt that you create so much value in our society. My question is, why does our society require heroes like you, hundreds of thousands of dollars and years to get help or compensation for injured people? Is this system the right system? Knowing that this system really also stands on the shoulders of giants such as you, your partners, other reputable injury lawyers, knowing that you guys bear this system on your shoulders and do so much good work. But still, isn't it too much? Isn't it too expensive? Isn't it too long? Isn't it too hard to get compensation and to get a justice for injured people?
You're very kind, Will. Thank you for saying those things. And I consider myself just an advocate for these clients I have, and I do my best for them. And yeah, it's a good question. There's different systems in different provinces where there's limits on what you can do and what you can sue for in court. And I think what you're asking about is money really going to compensate these victims of accidents, and is it really necessary? 100% I believe it is. I think it is because these accidents aren't temporary things. They're not, it's not very unfair. The system itself is very unfair. No, I always tell my clients money's never going to bring back a lost loved one. We deal with a lot of tragic, like there's so many cases, and it does weigh. We can save that for a different question, but um, we deal in tragedy every day, and I'm helping people and whatnot. When it comes to compensation for injuries, there are limits on what you can get. It's not the US here. I'm not really concerned about overcompensating anyone because those losses are very real. If somebody's been providing something for somebody, there is auto insurance. We're not personally going after people. We're going after insurance policies to protect you, and you have your own insurance to protect you for these kind of things. Once somebody's gone, it's we've all dealt with loss in our lives. They're just gone, and life goes on. And sadly, people are left to pick up the pieces. Compensation, let's be honest, it helps with that. It helps, doesn't restore, but it helps. And so I don't have any, I strongly support, getting compensation where you can, where it's legally allowable. to help those people because yes, you'll never be restored, but at least you'll have some something to help you get through. And so that's what we're providing. That's what the law allows. Um, I think there needs to be a lot of education to the general public about how this whole system works. I think people think, oh, you're going to take somebody's house or you're going to take someone's livelihood. No, that's not necessarily what we're doing. There's insurance and compensation that people have in place because accidents happen, tragedies happen. And in the system in Ontario, the government wants people to be compensated for that. So um, I really wish there was more education, a lot on the compensation rules, and especially in auto accidents, they have their own rules. There's so many obstacles that have been lobbied, and I don't want to go on a rant here by the insurance field to prevent fair compensation, in my view. So there's a lot of organizations trying to advocate and spread the word and through social media, and I'm glad to see that. So yeah, that's generally my. I hope that's an answer to your question, Pulat, but that's my perspective and take on it.
What if the government set up a pool of money, a large pool of money, and what if the government created a an arm's length commission of doctors and other health professionals, maybe other experts, who would accept applications for compensation from injured people and award them compensation from that pool, regardless of who caused the injury?
Mhm.
What do you think about this system? I mean, the problem with the system, it would remove the personal injury lawyers from the equation, right? So it's kind of, I'm kind of asking you to work against your interest in a sense, but I know that you are extremely intelligent and unbiased, capable of unbiased judgment. So I was wondering what you thought about it.
Yeah, I think everyone has some inherent bias though, but um, I'm thinking of this. My concern right away was the compensation is decided by the government then.
Mhm.
So you have a fractured arm, they may say we're going to treat you like another individual who has a fractured arm, but hey, you were a AAA pitcher. You know, I think a jury, and we're big proponents of jury cases, is a big part of like I just gave the example of Justice Garika and promoting jurors to participate because the community should be involved. So a system like that, and they do exist in other provinces where they have a pool of money, and you don't need to have so much litigation around pain and suffering and damages and such. I think the community and society has to really hold people accountable as well for the wrongs, not just the government, because the government is very busy. Obviously, there's a lot of things going on. That just becomes another issue for politics to play in and lobbying and all that, not justice, which is, in my view, what society should have a role in. Now, you don't need juries for every case. I've done non-jury trials and gotten good verdicts. I've done jury trials and gotten good verdicts. Yes, you don't necessarily need a jury for every case, but I think what you proposed completely removes that. And that would be my concern. You're not in touch with what the general public or the community feels the person deserves.
So you don't serve a jury notice with every statement of claim then? If you don't, what is your analysis for deciding if you should serve a jury notice with a statement of claim?
Yeah, for me, we generally do it wherever we can. So we kind of just try to always have a jury. And you know what? Defense wants juries too. So I find that most defendants do. There's obviously cases you're not allowed to have a jury where you pursue an action against a municipality, for example. Um, so I generally always want a jury because I think um, it's a client too probably would be fine with having their public tell their story. But practically speaking, I've seen at trials, judges also understand and are um, as effective in sort of assessing compensation. But for me, when I give a jury notice, is because I want, like I just said in my last answer, is I want the community to be involved and decide this on what they feel is right for this individual.
What is your worst jury story? The scariest jury story that you can think of.
Oh, scary. I've got a lot of jury stories. I'll just tell you some. I don't know whether they're scary or not, but they're just kind of interesting. Um, what jurors are interesting. When they first come into a case, to the end of the case, they change quite a bit. They come in and they're first like, okay, we're here. I guess we have to be here. We're into it, but not really. And then once they meet the plaintiff, they meet the plaintiff's family, then they become like, oh, we got to really tune in. And about halfway through a trial, I find, and I wish I could just study juries because it is, and there's been movies about studying juries. People become leaders on the jury box. Um, and you start to see that. I kind of know who the foreperson is going to be, who's going to read the verdict, just from how the jury's been involved and engaged. Some interesting jury stories, though, would be like just ones that stick out. You know, I had one juror who used to always wear, he came to court every day, like for weeks, in some kind of athletic jersey. And so we start to predict, well, what's he going to wear today? And he'd know, and he'd nod at us, and he'd wear like a Blue Jays or a Red Sox and a hockey. And he just made a point of it. And then he'd look at us and so like there was a little bit of that. That was hilarious because we would pick it out. We had jurors are people. Sometimes jurors get sick. Sometimes jurors need to be excused. Sometimes there's certain things. Sometimes jurors like gasp at evidence, and I find that interesting. Everyone looks, and all as lawyers, we kind of see, oh, what was it that did that reaction? Jurors are people, right? And I think that how they react to certain evidence dictates how you steer the case too, because what you think is important may not be what a juror thinks is important. I've seen lawyers do kind of like stare down jurors. I'm not a, like they look at them each when they come in, and I don't really, I find that a little bit strange. I do study where I can, how a juror reacts to certain witnesses and examples and things like that. And you can see when a jury is sympathetic, and you can see when they're not. Um, Another juror story. I'm just trying to think. Um, I haven't had a juror just get up and leave and like say like, "Oh, this is nothing." No, that would never. They're always respectful. But I've seen jurors gasp and be shocked at evidence and visibly, but I don't see anything wrong with that. Uh, I can, yeah, I'll keep thinking, and if I think of another one, Paulette, I'll come
Let me
back.
let me ask you a question. So I want to spend the rest of our time together today talking about trials. I think this is really interesting to a lot of junior lawyers, and you know what? I think it's really interesting to a lot of experienced litigators, because I don't think a lot of litigators actually did trials. When you have a jury trial, you have two opportunities to address the jury: the opening statement and the closing statement.
Yes,
Tell me about those opportunities. You are talking to the jury of ordinary people. It's six of them, right? It's
yes.
six people in the jury box. Tell me about your style. Tell me how you do it. Tell me about the eye contact. Tell me about the intonations. Tell me if there is any, if you use any theatrical methods. Tell me about your style of addressing the jury at trial.
Okay. I'd say I'm myself. I don't try to put on a bigger show than I'm comfortable with because I find that jurors can sense when you're genuine. Okay, so um, I don't speak. I speak for maybe an hour on my opening, maybe an hour and a half if there's a lot of complex issues, and sometimes even an hour is too much depending on the
Too
case.
much.
I use demonstrative aids wherever is possible because if people's attention spans are what they are, the reality is people want to not stare at you the whole time. They want to see, not just hear. So I use demonstrative aids, photo boards, things of that nature, pretty much every opening. I take pauses. Um, I think a pause is a very powerful tool when you are presenting something and you want to place emphasis without being overly whatever about it. I find I make eye contact with each juror, just sort of panning through, but I'm not staring. Um, I kind of just try to speak in a manner that tells the story. You are a storyteller in the opening. Closing is different. Closing is argument, right? Closing is you heard everything that and seen everything that you were going to see, and now you have to decide the issue. So my openings are different than my closings quite a bit. My closings are a bit longer. My openings are more, and you have to be careful with an opening too. So you say, I anticipate this, and you want to leave them, in my view, with some idea of what's to come, but not tell them everything, of course, or tell them everything that's going to come. Um, I do move around a little bit, so I don't stand at the podium. There's a podium, I start there, and usually I'll just kind of walk away but come back. Of course, the court staff will get mad at you if you're not in range of the mic. But I do stand and by the podium and I kind of move a little bit. I have I don't know what it's called, like a stand where I put my photo boards up and I'll leave them there and I'll let them kind of see and then explain what this is about. I have my client right beside me. Clients, I think, are very important too, how they present, that they're listening, that they're involved. Um, what else? Yeah, I'm not overly loud. I try to pause. I speak quickly generally. I try to slow it down. I think there's like I've never done this before, but I'm sure there's courses and coaches and people that can help you with that.
Well, I don't think you need it anymore. After 12 years of trial practice, I think you can teach a course like that. Let me ask you this. Do you think that opening statements are more flexible and you can say more things? You have more leeway in opening statements, but closings are really tight and you are really restricted to talking about the evidence that the jury or the judge heard. There are very more strict ethical obligations about what you can say in closing, and in the opening you're sort of more flexible there. What do you think about this?
Yeah, I think it's actually the opposite. You got to be very careful with your opening. You don't want to
Hmm.
cause a mistrial. I find judges are not going to call a mistrial on a closing because you've already spent days and whatever, and the jury's there.
Yeah.
And they allow for argument. So it's kind of the reverse. You want to be shorter in your opening. You want to just sort of tread carefully with certain things, preface things where necessary. In closing, you can go for it. Sometimes, you can even use analogies, quotes, kind of things to stick in the juror's mind, and you can really, um, persuade them. I think, yeah. So I would say it's kind of the reverse. You want to be very careful with your opening. And for me too, I kind of just want to get the evidence and get it rolling because once the trial gets rolling, the
Hmm.
jury appreciates that, their time. You want to be ready every day. You want to have a witness there. Jurors don't like to be coming in and coming out, coming in and coming out every time there's a voir dire or an issue. So
Hmm.
you want to sort that out with defense counsel. You want them to say, okay, listen, we're going to have an issue with this witness saying this. Okay, let's deal with all that with the trial judge before we bring the jury in. That way they don't get sent out every time someone has an objection. You just don't want that. Um, so yeah, my openings, and I think with openings, you want to grab their attention, let them know what the case is all about quickly, let them know kind of not tell them the arguments, but why are we here? Why is there a dispute that has gone to this length? And it's because of this. This is what the battleground is in a way.
You certainly disclose your theory of the case in your opening statement, correct?
Yeah,
Okay.
exactly. You want to have a theory right away, and you want to even say it within the first three sentences of your opening almost. I always think
You
the jury and then go into it.
So you kind of prime the jury to make sure they know what to look for when they hear the evidence from the witnesses. Does it sound fair?
Very fair. Cases
Okay.
come down to like three issues, pull out. I've noticed like two or
Mhm.
three battleground issues. Like the rest of the stuff you're agreeable on, but there's two or three issues, and that's what cases sometimes come down to.
Right. Did you ever have opposing counsel object to your opening statements?
Knock on wood, no. I
Mhm.
haven't had an objection. I think I've had to object to maybe a couple of closings. One common thing just for the younger lawyers to watch out for is in a closing, a lawyer should not compare the case you've heard to other cases they have. I actually had a lawyer say, I've dealt out with these amputation cases, and this is, compare this to that. That's absolutely not what the jury's supposed to do. You decided on those facts. You don't compare,
Exactly.
right? So I've had that
Exactly.
happen once. It wasn't a misjudge, just a direction. Um, but no, thankfully, I don't think I've ever had to. No, had
Have you
not.
ever have you ever had a mistrial?
I had one. So this was a ski case we had, and it's a pretty important case on waivers. We went to trial,
Yeah.
picked a jury, and then this issue of the waiver and whether it should be put to the jury became an issue. We had to decide the issue before we got forward with the calling the trial and going ahead. So the judge ruled that we'll have a mistrial, we'll discharge the jury, we'll deal with this issue. And then we dealt with the issue, went to the Court of Appeal and all of that. So yeah, that's how that trial ended. So it wasn't necessarily an opening issue, it was more of a legal issue and whether the jury should decide the enforcement.
Preliminary issue.
That's right. That's right.
And the judge discharged the jury and made a ruling on the preliminary issue, which you or the opposing party appealed to the Court of Appeal, correct?
That's right. Yeah, we were successful on it, and then they appealed it to the Court of Appeal.
Right. And then the Court of Appeal ordered a new trial.
No, they found that we ended up resolving that
I
matter.
see. Okay.
So we didn't have to do another trial.
I see. All right. Let's talk about the role of a judge in a jury trial. So some would think that the judge is just a silent observer, a note taker almost. So tell me more about the role of the judge. And I know we talked about FaceTime with judges at trials, but do you really interact with a judge at all during jury trials?
You do quite a bit, actually. Yeah, more than you think, because they're the first ones in the courtroom. They are making sure you're ready for the day, and they're always ask if there's pretrial issues to decide. And there are little things here and there. So you do get a rapport with the judge. The first person you see, like I said, every day. Last person you see, because they'll discharge the jury and they'll tell you the plan, talk about scheduling, but they'll do a lot of rulings. Sometimes some judges will, ask a question or pose something, or ask for clarification from the witness if the witness is, needs a break or is unclear, some kind of technical issue. And judges are really into the case. They understand the issues well. Obviously as the case goes on. Sometimes they'll want direction for the charge, right? The judge and you interact on that. So it's quite a bit of involvement in a jury trial. Obviously, non-jury trial, the judge is the focal point. But there is still quite with a jury, the judge does a very important role and helps the trial run smoothly, of course.
So, a trial to me, it's like a mini trial. I'm sorry, it's like a mini lawsuit within the actual lawsuit because it has its own procedure. It has its own motions. To some, examining witnesses might look like examination for discovery. You cross-examine witnesses like you cross-examine witnesses on affidavits and motions. So it's a little bit like a mini lawsuit within a lawsuit. So I want to talk a little bit about trial procedure. So when you have preliminary issues, then they are basically handled as motions.
Yes.
Technically, someone raises a preliminary issue or an issue of evidence or an issue of trial procedure, and this is a motion. In a sense, every objection is a motion if you think about it, because I invite the judge to make a ruling on a question that you raise.
Yeah.
How are these motions in trials different from motions that most litigators spend 99% of their practice doing? I mean, there is no 7-day notice, of course.
Yeah.
There is no notice of motion printed on a.
No
Sorry?
affidavits.
No
Right?
affidavits, right? So
That's a big
the judge observed everything with his or her own eyes, right? But sometimes there are preliminary issues. So let's talk about the motions practice during the trial.
Yeah. That's it is very different in a way, but also the same in a way. The judge will, like I said, be the first person and say, is there anything we have to deal with today, counsel? And I might say, oh, we have a doctor so and so coming. Defense has advised that they want to limit the scope.
Mhm.
Okay, we have to deal with this on voir dire. Okay, so the jury doesn't even come in.
Mhm.
Do you have what statements of law on the issue rather than a factum? There's no
Yeah,
fact. It's a statement of law. And so you send up a statement of law, they do it, no affidavits in those. The judge will say, okay, do you want to make submissions now or do you want to take a break? I can review the material before you argue it. And it's done that day. And
that's
you got to be
amazing.
prepared. That's why as a trial lawyer, you're working the evenings because you might not know of a motion until the end of the trial day. And then it's like, okay,
Yeah.
tomorrow we're going to have to deal with it. So let's crunch, work tonight, figure it out, argue it, and then you get a decision right away. So
Mhm.
yeah, I never thought of it that way, Pula, which is interesting. It is like examination in chief is like a discovery, and then you have
Yeah.
cross
Yeah.
trial within a litigation itself, trial within a
Yeah.
trial,
Lawsuit within a lawsuit.
lawsuit within a
Like a
lawsuit. Yeah, obviously.
mini lawsuit within a lawsuit. Well, is it fair to say that most trial motions or trial issues are about admissibility of evidence?
Um, I would say 75%. 25% is about the scope of what an expert can say. That's a
Right.
lot of it.
Right.
Somebody said this. Oh no, it's a participant
Yeah.
expert. They can't say this. Yeah, so you got to be prepared to know the seminal cases, Westerhoff and G, and all those kind of things. And then there's always this standard bias kind of stuff like that comes up. So I would say 75% is admissibility. There's a photo of this, there's a chart or graph, an expert wants to use
Hmm.
this. We think it's prejudicial, blah, blah, blah.
Hmm. In your experience, when you go to trial, which is rare, and you are an experienced trial lawyer, and that's why you take cases to trial, is it fair to assume that opposing counsel will usually also be experienced trial lawyers?
Yeah, I see that. And that's kind of unfortunate because on the plaintiff side, you can always open up your own shop, As you know, you opened up quickly, you wanted to do that, and then you get in court. Sometimes on the other side, you don't get those opportunities, right?
Hmm.
So I'll be dealing with a lawyer I hadn't dealt with in the life of the file, and it's a new lawyer about a few months before trial that say, okay, I'm involved, and they completely take over the
Right.
litigation in a way because they're the trial lawyer. So yeah, it's different. I do trials against, and when I was younger and I was doing them, much, much more senior guys than me, who it's intimidating because they've done trials, obviously. Um, so yeah, I do notice that on a plaintiff personal injury side, that once you get to trial, you're dealing with a much more senior lawyer who's doing the file a little differently.
Right. So let's talk about witnesses a little bit. Isn't this the most fun part of trials? Examining witnesses and cross-examining witnesses. This is what trials are really about, is getting evidence to the adjudicator. Have you ever had surprise witnesses?
No, never a surprise witness.
But it's possible, right? Like, not me. I don't know. Even maybe like my uncle Vinny style. Somebody kicks the courtroom's door open and walks in and says, "Okay," and then the lawyer says, "My next witness is."
No, I haven't had a my cousin Vinny moment. I've had some funny moments in court for sure and unexpected surprises, but not witnesses. I did closest thing was we did the Zoom trial a couple of years back, and somebody showed up on the Zoom, and defense had summons them to bring some records from a physio clinic or something. It wasn't on their witness list because they didn't intend to call the witness, but the witness actually joined the Zoom, was on for 2 seconds saying these are my records, and that was it. That's the closest I've had. But no surprise witnesses. The judges are very strict on, doing these pretrial forms, narrowing your witnesses. These are your witnesses. No trial by ambush.
Is it fair to say that you, the plaintiff's counsel, personal injury lawyer, win your trials in chief, not on cross?
Yes, yes. I think that's a fair comment. If you don't have the evidence in chief, it's very difficult to sway somebody to completely reverse their opinion. I have had a couple of moments where a witness has said, you know what, I can't comment. And that's essentially conceding, right? I cannot say, no, I cannot disagree with that. And then that's the best you're going to get, really. Um, I'll tell you a funny one time I cross-examined this psychiatrist, uh, and he was very nervous, and I was surprised because that's another thing. You think these doctors and experts are hired guns, they say, or whatever, and they would be experienced, but how they present a trial is very different than how they write their report, and none of that report goes to a jury. All the jury sees is a person who may look nervous and say a few things, and and the witness actually had his shirt buttoned up and tie on. And by the end of it, he was like pulling on his shirt, loosening. And it was so obvious that he was so uncomfortable. And I can't believe he did that. And that was kind of a shocking moment during cross. And then the jury was kind of like not rolling their eyes, but like, it was obvious that they were not comfortable with the opinion they were giving. And by the end of it, it was okay. Well, at the end of the day, you don't really have an opinion that you can give to this court that you're confident in almost, and they had to agree with that. So that was kind of but that's very rare. I think you need it in chief in order to prove your case. The burden is always on the plaintiff, right? So what I often hear at trial is, well, plaintiff bears the burden, hasn't proved it, so you need it in chief for sure.
Right. So I have a question about closing statements. And of course, closing statements draw on evidence heard at trial. And how do you draw on evidence heard in trial? You gotta remember, as counsel, you gotta remember what the evidence was at trial. Now, if you also spent your time during trial eliciting that evidence, examining the witness, how do you remember? So is it an absolute must to have two lawyers at a minimum do a trial so one can take notes, or how do you handle that situation?
Yes, I agree. I handle it with two lawyers minimum. Sometimes we'll even have a third. Sometimes some of the law clerks, paralegal staff will come and observe and maybe take notes. Sometimes we'll ask the court reporter for a transcript for the day if it's a big witness. Um, so then we can incorporate that into our presentation at the end of the case. So you're right. When you're in the thick of it and you're the person examining, you're trying to get the evidence out, you're trying to get it out in a clear way. You're definitely not taking notes. And and if it isn't said, you're right, you'll be called out on that, right? The good thing with a plaintiff is you're going last. You're the last word. So I think that's a very powerful tool as a plaintiff lawyer, an advantage, one of the few that we have, is that you get the last word to the jury before they go in. So if there's something that the defendant said in their closing and they didn't give you the full picture, guess what? You've got to clarify that in your closing. So my closing kind of shifts. Sometimes I'll start drafting it during the trial too, and just add to it. So that's something to help with that.
What will it take the three main stakeholders in a courtroom at trial, the judge, the plaintiff's lawyer, and the defense lawyer, what will it take them to agree to use technology to record the trial, to generate the transcript on the go, to summarize the evidence on the go? We all heard about AI. We all heard about generative AI and LLM, large language models. Now, ChatGPT can summarize things instantly. Isn't that going to be so great for access to justice if we can have AI listen in on the evidence, immediately generate transcript for everyone, immediately summarize the evidence for everyone, answer questions immediately about the evidence for everyone out in the open? Isn't that going to make a huge impact on access to justice without prejudicing defense or the plaintiff? I don't know about the interests of the judge. I would assume that the judge's interests are the same as the interests of justice.
Mm-hmm, mm-hmm. AI is definitely here and coming for the legal industry in a good way. I agree. I think it's going to add a lot to some inefficiencies. Another funny story, I'm not going to name names, we had a trial where a court reporter fell asleep and lost a whole half day and was apologetic, not a whole half day, I should say a whole half of a witness, and was very apologetic. And I literally saw him nodding off. It's because we had the lights down and we had a screen up and we're going through things. And sure enough, that's what happened. So AI wouldn't do that. In terms of access to justice, though, like I think when you're at a trial, it's a different beast than when you're trying to push forward to through a case. There's lots of ways that AI could help with that process, scheduling motions, getting things argued, getting things processed. I'm glad to see we're now on using case lines and everyone's comfortable with that, uploading things and whatnot. Um, I actually think access to justice, I've been talking a lot with, law clerks in the office, is we have different regions in Ontario, different courthouses, sorry, based on region and groups of them. And they all have their own rules. It makes it very difficult to book a motion because there's a different process for a different region. There's a different filing process for a different region. If it was all centralized and it was all online, that would be, optimal, I think, in terms of access to justice, because often motion dates get lost and then you're waiting 6 months because of a filing issue, because of something that wasn't done in this region versus another region. It just isn't that, yeah, just not that consistent across. But for trial, yeah, if AI could summarize, listen in, give direct feedback, oh, for sure, it'd help you run a very efficient trial and make trial time shorter. I find trials sometimes take too long, and the courts are concerned about that too, as well. Of course, how long a trial takes. Judges want to keep things rolling as they should and get things in the hands of the jury.
As a personal injury lawyer, as a plaintiff's lawyer, do you ever have to deal with enforcing judgments, or it just goes without saying that it's always against insurance companies? They always cut a check.
Yeah, generally 99% of the time, but we have dealt with certain situations where we'll do a trial and there'll be a coverage issue and you need to enforce. Have I enforced a judgment myself against an individual? No, I haven't done that. We always look for coverage. We always look for somebody to pay or satisfy that judgment, but it depends on the case and it depends on the circumstances. I think there are some people who, operate without insurance knowingly, and it's just shocking that they would do that. Um, people should have insurance. And if they don't, and you go to trial, you get a judgment, yes, you have every right to try and enforce it. Your client does. We generally don't deal with enforcement though. So I can't say I've done that in my practice.
Right. So you're already an experienced trial lawyer. I have no doubt about it at all. You've been out there for almost 13 years. We graduated from Osgood Hall Law School the same year, 2010.
Mhm.
Where do you see yourself in 10 years, in 20 years, in 30 years?
Yeah, I haven't really, to be honest, I haven't thought that far ahead. As a lawyer, we all deal with planning 2, 3 years ahead because you got to book dates, and beyond that, I don't know. I think I'm going to stay in personal injury law. I find it very, very rewarding. I think it's telling a story. You meet so many families, you make such a difference. Very rewarding area of law. Very stressful too. I understand, and I was going to talk about that. Is you deal with a lot of tragedy, and you have to have outlets and things like that. So that's one thing about personal injury law that's unique to this practice. I'm sure family law, criminal law, it's high stakes. It's a lot of stuff too, but you really get to know your client, and not only your client, their family, their story, and everything like that. By the time of trial, you know them very well, and so does the jury. So it is very personal. Personal injury law is personal. In 10 years, you know, yeah, will I still be doing maybe more mentoring type of stuff, advising, helping other people get into the courtroom, because I feel like the younger lawyers should be doing more trials. And so maybe that a little bit of that. Um, yeah, more mentoring type of stuff and maybe advising would be what I say. But for now, I'm just sort of I want to do more trials and just see and try and get more verdicts and keep pushing.
You know, I think you will be an amazing mentor. You proved it to us today. I'm sure that so many junior lawyers and even law students will love learning from you today from this interview. Thank you so much, Peter. I really appreciate this conversation.
Thank you for having me, Pulad. It's been a pleasure. Thank you.